right, Miss Aurora is back. Here we go, Secured Entrepreneurs. First, let me thank all of you who have jumped on the calendar for September. I see you. I can't wait. I'm honored to work with you. All right. There are 2 VIP spots left for the month of September. You can either join us here in Las Vegas at the fabulous Four Seasons, or we can do your VIP virtual. It's up to you. Okay. Again, I had to break down the Secured Entrepreneur packages, the program, because many of you who are jumping on the calendar have a whole lot of things going on. So when you go to 𝐤𝐸𝐤�consulting.com, you will now see Secured Entrepreneur Beginner. That is the business formation along with the business credit enhancements. Okay. And you will also see Secured Entrepreneur Pro. And that is for the secured entrepreneurs who, yes, you may need another business formation, but you already know that you are ready, and you also pre-qualify for a business performance loan of maybe up to $3 million. You are ready to qualify for a business line of credit of up to $1 million. Okay, so go to 𝐤𝐸𝐤�consulting.com and you will see that. You will also see Secured Entrepreneur Legacy Wealth Beginner, and that's for all of you who know that you're ready to start your trust. And then you will see Secured Entrepreneur Legacy Wealth Pro, and that's for all of you who need everything. You need the trust, you need anonymous entities, blah, 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 blah. Okay, so secured entrepreneurs who are ready for their invisible LLCs, that is Secured Entrepreneur Beginner, okay? 𝐤𝐸𝐤�consulting.com. All right, now in this video, you all know you do it to me all the time. Miss Aurora received another message. This time it is a post that was going around Facebook. It may have been on other platforms. I do not know. Okay. And this post obviously was designed to assist. I don't know if it was to assist entrepreneurs or people in general with avoiding probate. Now, there are some things that the individual who created the post wrote that some people need some clarity on. So that's what we're going to get into in this video. Please, secured entrepreneurs, pay very close attention to what I'm going to share in this video. And I want to thank you all for emailing. Please continue to do so at info@𝐤𝐸𝐤�consulting.com. Now, are you ready? Okay, for those of you who do not know, I am Miss Aurora Day, and this is the Secured Entrepreneur Movement. So the very first thing that we see at the top of this post is make sure all bank accounts have direct beneficiaries. The beneficiary need only go to the bank with your death certificate and an ID of their own. Now remember, secured entrepreneurs, this post is designed to assist people avoid probate. Okay, so that first paragraph on the post is a little bit too vague for a lot of people. And they were like, okay, you mean to tell me that all I need to do, like, how am I going to do that? Because when I started a bank account, I don't see anywhere where it's asking me who my beneficiary is and things like that. Okay, now, so let me just bring a whole lot of clarity here. For starters, we all know, those of us who have, may have 401ks, we have trust accounts, okay? We have life insurance policies. We have investment accounts where, yes, that application is going to ask you to list a beneficiary. However, when you go to your average retail financial institution, the retail bank, okay, to open up a regular savings or checking account, you know that you do not get anywhere on the form that says to you, okay, name your beneficiary, name the beneficiary of this account. Okay, you don't get any of that. It is up to every individual to ask the bank for this particular type of account. Now, if you already have your checking savings account open, when you contact the bank, you would be asking to change the account to a payment on death type of account, POD, right? Ms. Aurora already spoke to the secured entrepreneurs previously about this. It is also referred to as a Tatin trust. When you ask the bank for this form, you let them know that, listen, I need to add a beneficiary to this account, okay, they will give you a designation form, all right? You will complete that form. You have now changed the account from your average checking account to a paid on death account, okay? So what that means is this: upon your death, the individual who is named as a beneficiary will have the opportunity to then gain access to the funds, okay? Now, remember in the video where Ms. Aurora talked to you all about the 𝐸𝐻𝐻 Trust, it was a question that came from a secured entrepreneur who was very concerned about what was going to happen if, in fact, they did this while they're still alive. Can these individuals have access to the monies while they're still alive? Well, the answer to that was no. It's still no, okay? Because the reality is the beneficiary has to prove that you, in fact, have transitioned, okay? So as long as you have the 𝐸𝐻𝐻 Trust, okay, connected to your checking savings account at your bank, yes, the beneficiary will have the opportunity to present the proper documentation, yes, identify themselves, okay, and they will then have access to the funds of that account, okay? They will have access to the funds of that account, all right? Now, there's a lot of people who like to name minor children as beneficiaries. That is not a good thing, because the minor child will not have access to the funds. The minor child needs an adult guardian, okay? So this is where Ms. Aurora has to tell secured entrepreneurs, okay, you need to have a trustee in place, because we don't do the will here. We don't do the will here. And I'm going to get into that in this video, okay? You must have a trust where you have a trustee in place, okay? And maybe the trustee is acting as the guardian, or you have already named someone in the trust who will be the guardian for the minor children. But you have a trustee simply because the individuals who would be named as your beneficiaries would actually be minors at this time. So someone will have to make an appearance at the financial institution, okay, to gain access to the funds. Now, when it is that you have all of this going on, yes, these funds will have the opportunity to avoid being probated, okay, because that was the basis behind this post. This post is telling people how to avoid probate. So if you don't want the monies in your accounts to have to go through a probate, and then your children, your grandchildren, other relatives, people who need access to the funds, okay, if you don't want them to have to wait until the probate process, and we all know that that can be a very lengthy situation depending on how large your estate is, okay, then yes, you are going to go and change the type of checking and savings accounts that you have at your financial institutions. You are going to ask for a 𝐸𝐻𝐻 Trust. They will give you the designation form that you will need to fill out. And once that is completed, you want to make sure that you keep it up to date, okay? Because sometimes the people that we name as beneficiaries will transition before you. They will transition before you. So if in fact that happens, yes, you've got to go back to the bank. You've got to explain that now I need to update my designation form because the original beneficiary is deceased, okay? So that's how you're going to handle the monies in the account. All right, let's see what's next. All right, so let's see the next thing that this person has in this post. It says TOD equals transfer on death deed. If you own a home, completing this document and filing it with your county saves your heirs thousands. That's the first lie. That's a flat out lie. This document allows you to transfer ownership of your home to your designee. All they need to do is take their ID and your death certificate to the county building, and the deed is signed over. That's a flat out lie. Doing this will avoid the home having to go through probate. That's a flat out lie. Okay. Let Ms. Aurora explain some things to the secured entrepreneurs. Yes, there is a transfer on death deed, but that transfer on death deed must be created way before somebody's death. Okay, it must also, in many states, be recorded before somebody's death. Now, the transfer on death deed is not going to save your heirs thousands because there are no tax advantages to a transfer on death deed, okay? How many of the secured entrepreneurs know that there are estate taxes, okay? Now, if you are blessed to live in a state like Miss Aurora lives in a state that has, no state income tax, things like that, your estate will not have state estate taxes, but your estate will have federal estate taxes to pay, okay? If you live in a state that has state taxes, state income taxes, then your estate will suffer both state estate tax as well as federal estate tax, okay? So there is no financial benefit. There is no saving heirs of thousands and all what the person is saying in the post. I'm debunking that 100% with a TOD, okay? The tax advantage, the saving that the person is more than likely trying to refer to is when there is a trust deed already recorded for the real estate, okay? And what that means is that now the beneficiaries, the heirs, anybody who is a part of this trust, the estate as a whole can avoid having to pay estate tax because this thing has already been handled, okay? This thing has already been handled. There's no probate going on here. We already have a trustee that's taking over. The public was notified years ago that this estate belonged to a trust, okay? Now, many people jump on Aurora Day Consulting's calendar, okay, because they have filed some document in some state that, they took some advice, they filed some document, and then the county recorder's office sends them a nice little letter. And the letter can be very scary because you don't understand why they're asking you for all of your documentation. They want proof as to who you are filing this, how you have the permission to file this, like what's going on, because it looks to us like you need to be paying some money, and somebody needs to be paying some money because there's a sale that happened here. Because that's what it looks like when you do this transfer. It looks like there was a sale. So, who's getting some capital gains taxes? Was there a 1031? Like, what's happening here? They want more information before they honor the request to actually file this new deed that you're taking down there. And I've had several people who have gone to other people and was like, all they're telling me to do is replace the trust deed so I can take the property out and do this and that with the property. And then I'm going to re-record the deed. Okay, go ahead and see what happens. Because these are all taxable events. And that's one thing people don't understand, that you are creating a taxable event and you will get a letter about it. So let us not play these games. We always need the correct information. So Miss Aurora is debunking this entire paragraph, and I'm saying thumbs down to the TOD. That's from the Trust Goddess. Okay, next. Okay, so the next thing that the person is talking about is this living will. Living will allows one to put in writing exactly what you want done in the event. You cannot speak for yourself when it comes to healthcare decisions as well as other final decisions. Okay, I don't have a problem with the living will. I don't have a problem with the living will. I personally do not agree with the living will. I do not encourage clients to create a living will. I do not encourage clients to create standalone living trusts. Okay? I encourage clients to create irrevocable trusts that have a living trust attached to it so that trustees know exactly what the directions are that the individuals have for themselves as it relates to the event that they should become incapacitated. Because along with that, yes, the next things that the individual puts on here make sense. He's got durable power of attorney, allows one to designate a person to make legal decisions if you are no longer competent to do so, as well as a power of attorney for health care This document allows one to designate someone to make healthcare decisions for them. I'm in agreement with the durable power of attorney as it relates to the finances. I'm in agreement with the durable power of attorney as it relates to health care. Now, this is why the trust is so significant. And this is why you need all of this wrapped up in your trust, a solid trust, simply because you need to have all these key players in place. All right. Sometimes the durable power of attorney for healthcare as well as finances, okay, happens to be the trustee because of the family dynamics. Sometimes, we've had clients who have family members that they simply do not trust. Let me just go here because we're all adults on this channel. Some of us have families that have the resident crackhead. They have the resident addict. Some addict in some way. They have the resident thief. You can't let this person in your house because they're going to steal from you. There's certain family members that we're not including in a doggone thing. And it's a shame that these are the people that unfortunately we have to depend on. So the individual will select a trustee that they trust to play those roles. So that trustee will have the durable power of attorney for healthcare, will have the durable power of attorney for the finances, okay? Because most of the time there are minor children involved. Or in many cases, we've had many clients who have impaired people involved. And these range from children to adults who are physically impaired. They were born physically impaired, or they became physically impaired, or they are mentally impaired. Okay, so there is a trustee in place. There are caregivers in place who have these permissions, documented permissions to make decisions. Okay, now all of the secured entrepreneurs know that I am not a fan of the will, especially if you have a will done by not all attorneys do this, okay, but there's this little nasty trick that happens, okay. Now, the will leads you to probate, okay. The will does not help you to avoid probate at all, so we do not do the will around here, okay, because your family's going to probate, buddy, okay. Now, if you mess around and you have a will done by a firm, an attorney or a law firm, okay, sometimes some attorneys, and there's many cases where people have gone to jail for doing this, okay. These individuals will name themselves as the executors, the executrix, okay, and what they do is they file the original copy of the will in the probate court. How many of the secured entrepreneurs know that you cannot get into probate court with a copy of the will? You must have the original, right? Okay. But unfortunately, some of these people who decide to be crooked, they keep the original and they file the original in the probate court. Now, when you transition, your family has no choice now but to go to this firm and say, listen, we went to the probate court. They're telling us we can't do anything because we only got a copy. We don't have the original. We need the original. Oh, the original was only filed. And 9 times out of 10, they've already found out this person is the executor. What? Like we know that didn't happen. You know what I'm saying? Like, this is a problem. This is a problem. So that means that the family is stuck now paying this firm X amount of dollars for each hour they claim that they're handling the probate of the estate. Okay. It's a money grab. So we've got to be careful with that. So I'm going to debunk this portion of the post as well, simply because it's more than just saying I'm going to create a living will. It's more than just saying I'm going to have a durable power of attorney for my finances. I'm going to have a durable power of attorney for my health care. No, you have got to have a solid foundation for all 3 of these things, okay? And if you're going the living any route, it would be under a solid trust foundation where you have a living trust attached to it so that the trustees are aware of your instructions, what's going on, where the assets are. You may have 2 trustees involved in this situation, but at no time do you want to do that because there are no tax advantages to anything living. Now, isn't that interesting? Isn't that interesting? Anytime you hear living trust, that means revocable. That means that there's a grantor who's also playing the role of a trustee. Okay, that is also considered a grantor trust in many cases. There are no tax advantages. Why? Because these people, the people they're alive. The grantor and the trustee are playing the same role. Okay, it's not irrevocable. All right, so you would need to have a solid irrevocable trust. Okay, where you have these things attached to it, so that again, the family does not have to go through not only not going through the probate, but also legally avoiding the estate taxes. All right, let's see what else he has on this post. All right, Mr. Roy wants to tell you that Mercury retrograde has been kicking our butt in here with these recordings, but we're going to move on. All right, so this next thing that this person who wrote the post puts in here lights my fire. It's like, oh my God, like this is such poor information. I'm so sorry. 𝐸 secure entrepreneurs, please, please, please hear this, okay? This is what the next thing that is written in this post is. If all of the above is not done, you have to open an estate account at the bank. All money that doesn't have direct beneficiaries goes into this account. You have to have an attorney to open the estate account. The attorney also has to publicize your passing in a newsletter, in a newspaper, or post publication at the county courthouse. To allow anyone to make a claim on your property is a complete pain. 𝐸. I really don't know how this person pieced this information together, but it's not correct. Okay, so allow Ms. Aurora to explain this, because we've had many people get onto the calendar wanting to know why it is they listen to somebody, whomever, people know who these people are who give this misinformation out. Okay, they got an EIN for their name as the estate of whatever your name is. Okay, so we're going to say the estate of Aurora Day. They went to the bank. They tried to open up a bank account. They were told, okay, you got to get out of here with this nonsense. And some people got letters from the Internal Revenue Service asking for the decedent's last or the final tax return. Okay, and they were like, what is going on? I'm supposed to be able to do this and that and that. So then I have to explain to them exactly how they're going to, how you would operate your estate while you're alive. And that would happen via trust, because the estate bank account is temporary. It's designed to be temporary. So upon your death, whomever is in control of your estate, if in fact you did not have a trust and the estate has to go through probate, okay, the individual, the executor or the executrix, would then have to get, if the estate, okay, so if you had a will, let me take it from here. If you had a will, so we know we're going through probate. If the estate is substantial, there's an executor or an executrix named. That individual would then get a letter of testamentary. Okay, so the letter of testamentary is given by the probate court. And that means that the court is acknowledging this individual as the individual who's going to now handle the finances, handle the closing of the estate, things of that nature. There is also a letter of administration for individuals whose estates go through probate that do not have a will. Okay, now that person who's in control of these things will then go on to IRS.gov. They will obtain an EIN number for the estate account. They will go to the bank. The representative at the bank would need to see either that letter testamentary or letter of administration, okay, to state that you have the permission to open up this estate account, and that permission came from the probate court. Okay, the account is open. Now, if there's property that needs to be sold, if there's a home, whatever it is that belongs to the decedent's estate, okay, all of that money goes into that account. That account will now pay all of the debts. That account will pay out inheritances. Okay, that account will take care of the final taxes, all of these things. Okay, and once that is done, that account is closed. All right, that is the estate account, plain and simple. There's no extra, none of that to it. That is the estate account. Okay. Now, for those of you who are going to ask, well, can I do an estate account without probate? You sure can. It is called a small estate account. Okay, it's a small estate account. That would be between $50,000 and $166,000. Okay, so you would have to be between those numbers, $50,000 and $166,000. Mr. Rowe can't make this up. Okay, this is the rules. Okay, so again, you would get the EIN for the estate. Okay, you would take that along with. You still need a letter of administration. You still need a letter of administration, or you need a small estate affidavit. Okay, you need a small estate affidavit or a letter of administration for the small estate account. Okay, you take that to the bank so the representative knows, okay, this is going to be a small estate account. Again, it is temporary. Okay, so please, secured entrepreneurs, do not fall for the okie doke, because there's a lot of misinformation out here. People do not know what they're talking about. You're following up behind these people and you're embarrassing yourselves. Okay, I have heard the horror stories. Again, I want to thank you for emailing. Please continue to do so at info@auroradayconsulting.com. Okay, so that's what Ms. Aurora wants to share with you in this video. Ms. Aurora is going to be back because there's a few videos that I said I was going to make for you all, because it's a whole lot that's been coming in, and I'm going to go ahead and give my commentary and tell you all what you need to do, what you don't need to do. Okay, so you can find me, Ms. Aurora Day, at auroradayconsulting.com. And until next time, ta-ta.